Mikhail Kashubsky is a senior lecturer at the Centre for Customs and Excise Studies and head of Secretariat of the International Network of Customs Universities. He is a graduate of the University of Canberra and a qualified Australian lawyer. Mikhail teaches several subjects at the University of Canberra, including International Commercial Transactions Law, International Supply Chain Management, and Transnational Crime. His research interests include international trade law, customs law, offshore oil and gas law, maritime security law, and marine environment pollution law. He has also written publications on these topics. Without further ado, I'll hand you over to Mikhail to begin this presentation.
We'll briefly discuss in this webinar. First, by way of introduction, we will look at the overview of the international transaction process. We'll look at the key parties involved, some of the key documents, and the terminology that is used in international trade. We'll then look at the risk management in international trade, at types of risk that occur in international trade and the possible solutions that the traders can adopt to minimize those risks. We will also look at some transport options. In particular, we'll look at factors that influence the choice of transport by traders and some of the key considerations relating to those choices. One of the important questions in international trade that always arises is what is the applicable law, or what is the governing law that governs the transaction? And we will also look at that aspect. And finally, we'll look at Incoterms generally, but more specifically I'll provide the Incoterms 2012 overview and discuss some of the issues there, and we'll also talk about the proper use of Incoterms. In this webinar, we'll be looking at international trade transactions in the context of private international law, that is commercial transactions between private parties, such as between companies or between companies and individuals, as opposed to public international law. And we will also have a particular focus on the international sale of goods rather than the sale of services. Well, customs officials and traders must have a sound appreciation of what of the international trading practices, including the commercial and legal aspects of international trade transactions, especially international sale of goods. So the first question that arises is, what is actually an international sale of goods? And an international sale of goods can have different meanings and can be defined in different ways. For example, it can be defined as movement of goods from one country to another, or it can focus on the place of business of the parties to the contract, which is the concept recognized under the international law. And there are three essential elements in the international sale of goods. First, there must be a sale, which is different from the exchange of goods or counter trade or barter as a means of international commerce. Second element is that the subject of the sale is goods, as opposed to services, which has a different meanings under different laws, the word goods. So that element is important. And thirdly, the sale is effected at some kind of international level, involving various international elements, such as, for example, a foreign buyer or foreign seller, foreign origin or destination of goods, foreign banks and financial institutions, application of foreign laws and jurisdiction, as well as other areas. So fundamentally, the international sale of goods is the sale that involves parties from different countries. And the contract dealing with such a sale or transaction is the contract for the international sale of goods. On this slide, we will look at some key parties that are involved in the international trade transactions. But the transaction only occurs because of the two principal parties in the transaction, that is the willing buyer and the willing seller. And these principal parties, the buyer and seller, or sometimes they are referred to as exporter and importer, they need to manage their interaction carefully, particularly in relation to exchange of documents. And even in the simplest of international transactions, there are usually many other people that are involved between the principal parties, between buyer and seller. And these include carriers, freight forwarders, insurance brokers, financial institutions, and government authorities such as customs or other border agencies. The processes involved in international commerce can vary considerably, and some of the examples of influences that occur in the international transaction include the relationship between buyer and the seller. That includes whether parties are known to each other, whether they had past dealings, the level of trust that exists between the parties. Also, the nature of goods is an influence. For example, whether goods are hazardous goods or whether they're perishable goods. Also, the extent of the contract. Is this a one-off sale, or is this a long-term contract over a certain period of time? That may affect the terms of the contract itself. The regulatory environment is also important, and also the requirements of financial institutions that may be involved in the transaction. On this next slide, you can see an overview of the typical export and import transaction between buyers and sellers. So you can see here in step 1, we have a buyer and the seller. The buyer is from the United States and the seller is in Japan. In step 1, they conclude a sales contract with a method of payment which is usually a letter of credit. So that's step 1. In step 2, the buyer goes to his local bank and applies for a letter of credit in favor of the seller. In step 3, the issuing bank then requests another bank, usually a correspondent bank in the seller's country, to advise and usually confirm the credit. In step 4, the advising bank, usually in the seller's country, forwards the letter of credit to the seller, informing about the terms and conditions of the credit. Then the seller in step 5 checks whether they're happy with the conditions of the credit, prepares the goods and relevant documentation, and arranges the delivery of the goods to the carrier. Then the seller presents documents evidencing the shipment, such as the bill of lading, to the bank, and the bank will be willing to negotiate under the terms of credit. In step 7, the bank examines the documents and drafts them for compliance with terms of the credit, and if all terms of the letter of credit are complied with by the seller, the bank will pay or accept or negotiate. In step 8, then the local bank in the seller's country sends the documents and the draft to the issuing bank. In step 9, the issuing bank then examines documentation for compliance with the terms of the letter of credit, and if compliant, then the seller's draft is honored. In step 10, documents then are released to the buyer after payment or on the terms agreed between the bank and the buyer. And in the final step, step 11, the buyer surrenders the bill of lading to the carrier, which is in the case of the ocean freight, in exchange for the goods or the delivery order. So as you can see in the typical import and export transaction, there are several steps that are involved, and there may be many different parties that are involved in the transaction. In this particular slide, we only have here carriers and the banks. What's missing? There could be freight forwarders involved. There could be insurance companies involved, but this is just a simple summary of a typical transaction. In the next slide, we will look at the terminology that is often used in international trade transactions. And it is important to be familiar with some of the basic terminology and the context in which it is used. For example, a freight forwarder can be defined as a party who is involved either directly or indirectly or administratively in the movement of cargo produced and ordered by a party other than the freight forwarder itself from one country to another. Depending on the context, the buyer and seller, importer and exporter can also have different meanings. So, for example, on this slide, we have a transaction between the exporter, who is the seller, or an importer, a buyer, and depending on the context, the exporter or seller may also be known as a shipper or consignor. That's in the shipping arrangements, or in the transport contract they may be named as shipper or consignor. In terms of the banking transactions, they can be named as beneficiary, particularly under the letter of credit. The importer can be referred to as receiver or consignee under the transport contract, and they can be referred to as applicant or opener under the letters of credit. The export contract may be found in an export, sale or purchase agreement signed by both parties, or it may be composed form documents such as the purchase order or pro forma invoice exchanged between the parties. And you can see here the export contract is the main one, but it can also consist of invoices and purchase orders. This slide shows you the types of documents that are typically used in international trade. And the documents are very important in international trade transactions because it involves both the shipment of goods and the corresponding documentary exchanges. And some of the key documents involved in international trade the main document is, of course, the contract of sale. It is the principal document that governs the transaction between exporter and importer. But other documents that are almost always present in international trade transactions are bill of lading in the case of maritime transport, or other transport documents such as airway bill. The payment-related documents, here we have commercial invoice, letter of credit application. We can have documents relating to insurance, such as the insurance certificate or insurance policy. International contracts of sale are closely linked and even interdependent with a number of documents or contracts, such as contracts for the carriage of goods, insurance, and other documents. Documents that are involved in international trade transactions clearly indicate that there are many more parties involved in the trade transaction than in the domestic transaction. And these parties can vary from transaction to transaction depending on their complexity and the required logistics along the global supply chain. So the contract of sale is what can be referred to as the master contract ruling the whole transaction. And all other contractual arrangements will follow from the master contract, from the contract of sale. And those arrangements will cover transport, insurance, financing, any pre-inspection that may need to be done. And these documents should always be in accordance with the main document, which is the contract of sale. It is the most important document in an international sale transaction. And the contract of sale should record and reflect the intent of the parties, and that everything that has been agreed between them. A good contract would have that spelled out in writing. And a contract of sale is the evidence of the agreement between the seller and the buyer. And it is also a record of what constitutes the agreed goods, the agreed delivery time, the agreed points of delivery, method of payment, and any other aspects. The second area that we will discuss in this webinar is risk management in international trade. Intelligent risk management is at the heart of international trade. While risk is an element of all commercial transactions, international trade multiplies and adds additional risks to those that are encountered in domestic trade. And all international trade transactions require careful management of risks and costs between the parties involved, notably between the buyer and seller. And buyers and sellers usually try to reduce their risks or limit them in some way. And with modern trade being so complex between the parties and possibly involving a good number of service providers in the transaction, which we discussed earlier, it must be realized that each service provider is undertaking to provide a service and therefore wants to protect their own interests in the transaction. And especially if something goes wrong, such as the unforeseen circumstances. There are a number of different types of risks that are involved in international trade transactions, and this slide shows some of the categories of risks. For example, there are transport-related risks. International transactions tend to involve greater distances, with cargo often changing hands or undergoing prolonged storage. So there is a higher risk of damage, loss, or theft than in the domestic trade. Consequently, exporters and importers must understand their legal rights against carriers when something occurs during transportation. There are also credit risks and what can be referred to as non-payment risks. And since it is often difficult for exporters to verify the creditworthiness and reputation of foreign buyers, there is an increased risk of non-payment or late payment or even outright fraud. Accordingly, exporters frequently insist on payment by irrevocable documentary credit or a letter of credit, and make use of other security devices such as a bank guarantee. So to avoid the risk of non-payment, some strategies can be implemented to reduce that risk. The quality of goods risk, and this refers to when the importers may find it difficult to physically check the quality of goods before shipment, and sometimes they may receive goods of the quality that they did not expect. And one of the ways of avoiding this is for the importer to insist on provision of an inspection certificate, or to do what is called a pre-shipment inspection in the country of origin. Another risk is the exchange rate risks. And if a price has been set in a particular currency in an international contract, subsequent exchange rate fluctuations between the contract currency and the accounting currencies of the parties, the buyer and seller, this will inevitably benefit one party and may cost the other party. So the easiest solution for a party wishing to avoid uncertainty is simply to stipulate the contractual prices in their own currency. This is one of the ways, but there are other possible ways to minimize that risk. The unforeseen events risk, this refers to a strike, a natural disaster, or a war that may render delivery of goods impossible. And unexpected events may also dramatically alter the costs of transport by raising the price of shipping fuel, or by closing off the most economical transport routes. So a well-drafted contractual force majeure provision can help to protect parties from this risk. Legal risks are also important. Foreign laws or regulations may change or may be applied differently in the past, and it may impede or frustrate the international transaction or the contract that you have. For example, a customs license may be suddenly very difficult to obtain or even impossible to obtain. So whenever a contract is subject to jurisdiction of a foreign court under foreign law, the risks exist that it may prove impossible for the other party to obtain a quick decision in court in the event of the dispute. So legal risks and differences between legal systems in different countries are important and should be taken into account by traders. Investment risks are those that relate to marketing any product to a particular country or entering into an export program. For example, a market that has been steadily growing for several years may suddenly decline due to, for example, exchange rate instability before an exporter can amortize their investments in local distribution. So companies should begin by seriously considering whether or not to export at all to avoid those investment risks. On the next couple of slides, we will look at the specific examples of risk management in international trade. So in case when there is a risk of misunderstanding, a risk of disagreements over payment terms or quality conditions, some of the possible solutions or risk management tools that can be adopted include substantial credit checking of the counterparties, negotiating for minimum legal protection, and using well-drafted contracts of sale that cover those areas. When there is a risk for the exporter of non-payment, the exporter can, for example, use a documentary letter of credit under UCP 600 to protect themselves from a risk of non-payment. Or alternatively, they can trade using the cash in advance payment method, or demand a bank guarantee from the buyer to protect themselves. If there is a risk of loss or damage in transit, or that part of the shipment will be stolen, and there is such risk, this is a transport-related risk, and the possible solutions to deal with that risk can be simply arranging sufficient insurance cover, which can cover against a variety of risks, including theft or any other risk. And another way to reduce that risk could be a proper review of conditions in the contract of carriage to see what sort of liabilities the carrier is subject to. Proper packaging and proper shipment instructions in the contract of sale are also important and can reduce those risks from occurring. Now I would like to discuss some of the transport options. There are three main modes of transport, as you would know: the air, sea, and land, which includes rail and road. So when it comes to the choice of transport, the ultimate question is, how should the goods be transported, or what is the most suitable transport option for this transaction? And there are a number of factors that influence transport choices, and they can be grouped into three categories: physical factors, market factors, or financial factors. Physical factors relate to questions such as what options are available. There might well be major influences affecting a particular order simply due to the fact that certain parts of the journey do not enjoy certain transport options at certain times of the year. Or there might only be one option available in a developing country. Other relevant questions are: what is the nature of cargo? Is it heavy or is it bulky? Is it just bulky but very light? Or is it small but very heavy? Things like this definitely have an impact on the choices on the choice of transport. Financial factors can involve questions such as what is the cost of freight. There are also various financial formulas that could be very useful to work out what financial issues are at stake in a particular shipment. What interest are we paying on the loan obtained from the bank to finance this transaction? What is this worth to the transaction? It will be different for the buyer than for the seller. In certain scenarios, you even might find it more cost-effective to move the same cargo by air rather than by sea. Market factors include things like what are the commercial influences involved? Is there a seasonal cargo involved, limiting of the timing, where timing is very important? Every relationship has its seasons that influence a good or bad deal. So seasonal goods, if you're trading in seasonal goods, that can have market factors can have a major impact on the mode of transport that you use. So some of the key questions that we need to ask when considering the choice of mode of transport include what transport options are available between origin and destination. For example, is the country a landlocked country where maritime transport is not available? What infrastructure is available in the countries? What is the mass, volume, and dimensions of cargo? What is the nature of cargo? For example, is the cargo hazardous, or are you selling perishable goods? What are the restrictions that would apply on the shipment? So, for example, as you would know, some countries have certain quarantine or health requirements, and depending on the nature of goods, and that could influence the choice of transport as well. What is our timing? How quickly do we need to get those goods to a required destination? And what are the costs of freight of different modes? These are the types of questions that can be asked, but there are others that we can ask. The next important aspect of international trade transactions that I would like to talk to you about today is the applicable and governing law of a transaction. So the question is, which law applies to the transaction? In this example, there can be an Australian manufacturer that exports goods to the United Arab Emirates, and the question is it the Australian law or the Emirates law that will apply to the transaction, or is it the law of a third country that will apply? So these are all relevant considerations. So depending on the phase of the transaction, different sets of laws can apply at different stages or aspects of the transaction. In any international sale of goods transaction, there may be 3 different regimes that we need to consider. So in relation to the sale of goods, there can be 3 possibilities. It can be the contract can be governed by the domestic law of the place where the contract was concluded, or it can be governed by the law of a third jurisdiction, or it can be governed by CISG, and CISG stands for the United Nations Convention on the Sale on Contracts for the International Sale of Goods. It was adopted in 1980, and it is the principal international convention that applies to contracts for the sale of goods between private traders, not between the governments. So in relation to the carriage of goods, for example, carriage of goods can be governed by one of the international conventions that is applicable to the carriage of goods. For example, it can be governed by Hague rules or Hague-Visby rules or Hamburg rules, which deal with carriage of goods by sea. Or if we are using air transport, it is possible that the Warsaw Convention or the Warsaw System or the Montreal Convention can apply to the carriage of goods. So depending on the aspect of a transaction, different laws can apply. In terms of the jurisdiction and the choice of law, in international contracts of sale, the parties have a choice as to the law that applies to their contract. There is a freedom of contract and freedom of choice of law. So a properly drafted international contract of sale will therefore contain answers to questions such as what law governs this contract of sale, or in which court or other forum should the case be brought in the event of a dispute. So how do we determine which law applies? In order to determine which law applies, we first need to look at the contract itself to see whether the applicable or governing law is specified in the contract. When it comes to the contract of sale, we would look at the governing law clause, and similarly, when it comes to the contract for the carriage of goods, we will look at the governing law clause or the applicable law clause to see what law applies. A bill of lading normally would have, on the reverse side, it would have the terms and conditions, and usually it has provisions that deal with governing law. If the contract does not specify the governing law, then the second step would be to look at the scope of application provisions of the relevant conventions. So if we're talking about the sale of goods, we would look at the CISG, Article 1 of CISG. And just as a reminder, CISG is the United Nations Convention for the International Sale of Goods. Article 1 deals with the application, and it specifies the circumstances and transactions to which the convention will apply. In relation to carriage of goods by sea, for example, we can look at Hague and Visby rules or any other convention. I just provided an example here that in Hague-Visby rules, it is Article 10. This deals with carriage of goods and the governing law, applicable law. And this is what Article 10 of the Hague and Visby rules actually says. The provisions of these rules shall apply to every bill of lading relating to the contract, to the carriage of goods between ports in two different states if the bill of lading is issued in the contracting state, if the carriage is from a port in the contracting state, or if the contract contained in or evidenced by the bill of lading provides that these rules or legislation of any state giving effect to these rules govern the contract. So this you can get an idea of what sort of things you can look at in terms of the transaction to determine what the applicable law to the carriage of goods is. You would look at what are the contracting states to Hague and Visby rules. Is the country that you are shipping from a contracting state? If yes, then it will be then the Hague-Visby rules will apply to the transaction. So first look at the contract. If it's impossible to determine by looking at the contract, look at the relevant conventions and look at the scope of application provisions in those conventions. I'm gonna leave the presentation for a minute and show you an example of a bill of lading. This is a bill of lading that is used by a Japanese company, and you can see that here the shipper and the consignee are specified. This is the front page, so usually there would be a description of goods, but I would like to focus on this second page, which sets out the terms and conditions of the bill of lading. In particular, you can see here clause 2 and clause 3, which this clause 3 deals with governing law, and it says that the contract evidence by or contained in this bill of lading shall be governed by the Japanese law, and if any dispute arises, the bill of lading shall be referred to an arbitration in Tokyo. And this clause paramount, clause 2, as you can see, it refers to the International Carriage of Goods by Sea Act 1957 of Japan, and it says that this act is given effect to the protocol to amend the Visby rules and the protocol amending certain rules relating to the bills of lading, and this relates to the Hague and Visby rules. So by looking at this bill of lading, we can see that the applicable law would be the International Carriage of Goods by Sea Act, which is the same as the Hague and Visby rules, and that in the case of dispute, the dispute should be resolved by way of arbitration in Japan. There is another interesting provision in this bill of lading, which I'm going to show you. It is clause number 28, U.S. clause paramount, and as you can see, it says if the carriage covered by this bill of lading includes carriage to or from a port or place in the United States of America, then the bill of lading shall be governed by the United States Carriage of Goods by Sea Act 1936. And the United States Carriage of Goods by Sea Act 1936 gives effect to the Hague rules. So we can see that there is this exception specifically relating to shipments to the United States. So, and the liability per package here under the United States legislation is $500 per package, which is different from the liability under the Hague and Visby rules or even Hague rules. So we always need to be aware that there may be, for example, in this case, for shipments to the United States, a different law applies. So this was just an example of one of the bills of lading. Now, I also would like to talk to you briefly about the impact of the domestic law on international trade transactions. And domestic law can affect contracts for the international sale of goods. For example, certain aspects of the international sale which are not covered by international convention, for example, such as passing of property or the validity of contract, they're not governed by international convention, but they're governed by domestic law. And also domestic law can have an impact in terms of compliance with government regulations controlling the movement of goods across borders, such as import and export controls, customs duties, health inspection requirements, quarantine requirements, and any other requirements that may apply. So because of the nature of international trade is between persons from different jurisdictions, it is important for traders to understand their legal obligations in different countries, in those countries that, that they trade with. So the national laws that relate to international trade transaction may differ, and the national requirements may differ from country to country significantly. Now I would like to look at Incoterms. Incoterms, there are internationally recognized set of terms codified for international use in international trade. Incoterms stands for International Commercial Terms. They were developed and published by the International Chamber of Commerce, and they can be described as a system of expressing commercial terms as a universally understandable set of codes. The purpose of Incoterms is to provide a set of international rules for the interpretation of the most commonly used trade terms in foreign trade. Accordingly, the uncertainties of different interpretations of such terms in different countries can be avoided. That's why they've created a set of universally recognized terms, and they allow buyers and sellers to establish to clarify their individual responsibilities to the other party, and thereby hopefully minimizing disputes. And using a standard set of commercial terms reduces the possibility of misunderstanding, well, in theory. The International Chamber of Commerce introduced the first version of Incoterms in 1936, and since then they have been updated a number of times to keep pace with the development of international trade. They are adopted on average about every 10 years, and most contracts made after 1st of January 2000 will refer to either the 2000 or 2010 edition of Incoterms. Previous versions of Incoterms may still be incorporated into the contracts of sale if the parties agree so. Another point to make about Incoterms is that they are delivery terms, and as accordingly they are concerned with the movement of cargo from origin to destination and the associated processes necessary for such movements. Incoterms therefore spell out the rights, duties, and obligations and responsibilities of sellers and buyers against a specified term chosen for your contract. In 2010, the International Chamber of Commerce adopted the new version of Incoterms, Incoterms 2010, and they take into account the latest developments in commercial practice and consolidate some of the former rules. And I will provide an overview of Incoterms 2010 in the following slides, but before we do that, I would like to briefly discuss the three main elements in Incoterms, which are separate from each other, but although they may be interrelated. Essentially, Incoterms, they deal with three elements: actions, risks, and costs. Actions refer to responsibilities of the buyer and seller and their service providers in terms of, for example, whose obligation it is to arrange transport, or whose obligation it is to arrange insurance contract. Depending on the Incoterms we use, it can be buyer's responsibility or the seller's responsibility. Risks refer to a division of risks between the buyer and seller. And the important point relating to risks is to know at which point a risk transfers from one party to another. A point of transfer of risks is very important. And similarly, costs. Division of costs between the buyer and seller is also crucial. Who pays for what, or at which point the buyer starts paying for the transaction or anything that arises during the carriage of goods. So we need to know the point at which the transfer of costs and the transfer of risks. Incoterms 2010, they came into effect on the 1st of January 2011, and they consist of only 11 Incoterms compared to 13 Incoterms in the 2000 version. And they're mainly organized into two categories. The first one that deals with Incoterms that can be used for any mode of transport, and the second group contains Incoterms for sea and inland waterway transport only. Here you can see the list of terms for each mode of transport, and these two terms, DAT and DAP, are the new terms that are created in Incoterms 2010. On this slide shows simply the examples of Incoterms that are used for maritime transport only, so that's FOB, CFR, and CIF, and the Incoterms that can be used generally with any mode of transport, such as FCA, CPT, and CIP. I also would like to show you to illustrate the comparison between C and D terms. So what happens if the goods are damaged in transit? Who is at risk? And this is the relevant question. And the answer may be different depending on whether we use C terms or D terms. So under the C terms, if we use, for example, CIF, the point of transfer of risk is at the point of shipment, which is the same case under the FOB. So we can see here that the seller's risk only goes up to the point of shipment. And from then on, it becomes the buyer's risk. So if we use the D terms, however, we can see that the seller's risk goes all the way up to the point of delivery, or the terminal in the country of destination. So this is the difference between C and D terms. While the seller's costs remain pretty much the same, the seller's risks differ considerably. So if something happens during transit and we're using the C terms, it will be the buyer who will be responsible. But if we use the D terms, it will be the seller who will be responsible for the loss or damage to goods while goods are in transit. So this is a very simple way to demonstrate the difference between the C and D terms. So, for example, on this slide, it's maybe a little bit easier to see here that under the C terms, the seller's risks stop here at the point of when goods are loaded on board the vessel. However, the seller still has to pay the costs of shipment up to the port in the country of destination. If we compare it to D terms, for example, the DPP term, we can see here that seller's risks run all the way up almost to the buyer's premises. And the DPP term, delivery duty paid, is the term that places the largest amount of responsibility on the seller in terms of costs, risks, and actions that the seller has to do. Under the DPP, the buyer does not have to do anything at all, just collect the goods at their premises. And the DPP terms is the express carriers are usually the ones that use the DPP term because the goods are delivered to your doorstep, basically. And as a buyer, you don't have to do much except sign for them. So once again, looking at the comparison of C terms and D terms on this diagram. So if we use C terms, then the seller will say, sorry, they are shipped in a good order, so we are not responsible. But if we use D terms, then it is the buyer who will bear the loss. Oh, sorry, if we use D terms, the seller will bear the loss if something happens to the goods while they are in transit. So this is just the basic comparison between different categories of Incoterms. Some of the key points that I would like to make about Incoterms include first of all, that the incorrect usage of Incoterms can actually work against the trader and the service provider because they may have disregarded a particular term's intent. So trade practitioners need to consult the full official text issued by the International Chamber of Commerce and to be aware of many unauthorized summaries and approximate versions that are available on the website. If you use Incoterms often, do use the official Incoterms publication done by the International Chamber of Commerce. Another point to make about Incoterms is that Incoterms are not legally binding, and in order to be enforceable, they must be made part of the contract of sale. So one of your provisions in the contract of sale can be a provision specifically dealing with Incoterms, and you can specify which Incoterm you use. Finally, Incoterms do not cover all of the issues. They do not have answers to all of the questions in international trade transaction. And one of the principal issues that is not covered is the transfer of property or the title of goods. Incoterms tend to deal with possession of goods and not title to goods and ownership of goods. As a summary, we have covered in this webinar 5 areas, provided a general overview of the transaction and the key parties and documents involved in it. We talked about risk management in international trade and some of the options or solutions to manage those risks. And we talked about transport options and related considerations. We've discussed applicable law and governing law issues and how to go about determining which is the governing law or which is the applicable law to the contract. And we've discussed Incoterms and some of the issues relating to Incoterms. If you are interested in the further study on this topic, we have at the Center for Customs and Excise Studies a postgraduate unit called International Commercial Transactions Law, which is an elective in the Master of International and International Customs Law and Administration, and it covers a range of topics, and including what we've discussed today, plus much more. We also have a non-award vocational training course or short course called International Trade Transactions that also covers the similar issues. And the topics that are covered in those courses, they include characteristics of international trade transactions, the legal framework, the role of estimation, role of contracts of sale, sale of goods and Incoterms. We cover Incoterms in more detail there. The United Nations Convention on Contracts for the International Sale of Goods, or CISG as we refer to it. And we cover different transportation or carriage of goods by sea, by air, by multimodal transport. We cover international payments, insurance aspects, and dispute settlement. And if you'd like further information about these courses, please contact us at this address, or you all know how to contact us. And now I would like to answer some of your questions. We do have a couple of questions, and I am just going to read out the question.
So thanks, Mikhail. A few questions have popped up through the presentation, so I will just read them out. Just give me a second to flick through them. Okay, wow, it's definitely a very popular topic tonight. I definitely have a large number of questions tonight. I hope we have time to get through them all. A question that has just popped up is, are there any books available by the speaker? Now, Christine, thank you for that question, and I'm glad that you asked it, because I'm sure Mikhail won't mind my saying that he has actually just completed his PhD and is probably looking to write another book. He's shaking his head next to me. He's very modest, but thank you, Christine. He is very knowledgeable in this topic. I will read the first question that we have and then give Mikhail the opportunity to answer it. Now, the first question is, in relation to factors that influence the choice of transport, you mentioned that it may be cheaper to send goods by air than by sea in some situations. Please provide an example of a situation where it would be cheaper to move goods by air than by sea. Over to you, Mikhail.
Thank you for the question. I wouldn't, the word cheaper is probably not the best word, because air freight is generally more expensive than sea freight. However, a word cost effective is probably a more appropriate phrase in this context. So, for example, in the case of perishable goods, although the actual freight cost may be higher for air transport than for sea transport, if the goods are sent by sea, there are more chances that some of the goods may become spoiled or not suitable for consumption, which would end up costing more to the seller eventually. And if we have another situation where it may be cheaper to send goods by air than by sea, if we have a contractual obligation to deliver by a certain date, then it may be more desirable to deliver them quickly and not be liable for delays in delivery. So even though we may overpay for air freight, we will save on those possible liability costs. Also, it may be cheaper to send goods by air than by sea when we are paying a high interest rate on the bank loan that we use to finance the transaction. And it may be worth getting the goods to the buyer as soon as possible in order to get paid sooner and repay the loan. In other words, to pay more for air freight but save on bank interest. So these are just some of the examples where some of the examples of situations where the goods can end up traveling cheaper by air than by sea.
Okay, thanks, Mikhail. Now I'm just sorting through the questions, so bear with me, please. Okay, I'm not sure that we are going to get time to answer everybody's questions, so I am just filtering through them to see if we can answer them in a group way. Now, one from Phil. Yes, thank you, Phil. It was a very interesting presentation. Phil would like to know, to what extent do you think the new Rotterdam rules will have an impact on the efficiency of international trade? Over to you, Mikhail.
Thank you for your question, Phil. I cannot tell you the extent to which they will impact on the efficiency of the international trade, because at the moment there are mixed arguments about whether or not Rotterdam rules are useful, or whether they are more favorable to the shipper than, for example, the Hamburg rules. Yeah, it's difficult to say what impact they'll have on the efficiency of international trade, but I think the good aspect of Rotterdam rules is that it applies not only to carriage of goods by sea, but also when there is multimodal transport involved. So it is definitely a helpful convention from the multimodal transport perspective. However, the Rotterdam rules have so far proved to be not very popular. As far as I know, there is only one or two ratifications of the Rotterdam rules, and one of them was by Spain a few years ago. And in the last few years, there haven't been any more ratifications, as far as I know. And it will be some time before Rotterdam rules will come into force, if ever. So I think also the good aspect of Rotterdam rules is that they deal with electronic documents. They take that into account. The Rotterdam rules certainly attempt to address the developments that happened in international trade in the last quarter century, in the last quarter century since the Hamburg rules. So I think they will have a positive impact on the efficiency of the international trade. However, they may not have a positive impact in terms of the rights and liabilities of carriers and importers and exporters. Thank you.
Thanks, Mikhail. I will just go through the questions quickly. We do have quite a few to get through tonight, so just bear with me a second. Okay, great. Here's one from Catherine. Mikhail, what challenges does customs pose to market entry?
Thank you. Well, challenges that customs pose to mass market entry. We looked at the risks that are involved in international trade, and one of the categories of risks related to the legal risks. So in terms of the legal risks, for example, unfamiliarity with customs requirements and procedures in the country of destination can be one of the challenge to market entry. Unfamiliarity with customs laws, or even risks associated with difficulties in obtaining the import permit or an import license. So those kind of the issues that can influence or that can challenge, pose challenge to the market entry.
Okay, great. Thanks, Mikhail. We do have time for just one more question. I have noticed Phil has just typed in a quick response to Mikhail there in regards to his question before. He's written, "Thanks, Mikhail. Spain and Togo have now ratified, apparently. They're slow off the mark, this convention." Thanks, Phil. Yes, we do have time for just one more question, and then we're going to have to wrap it up tonight because we have gone over time. This one's from Shane. "If the contract does not specify the governing law and parties cannot agree as to what the governing law is, who makes that determination?"
Yeah, this is a good question. Thank you, Shane. And if the applicable law or governing law is not specified in the contract, then the court or an arbitration tribunal where the proceedings are initiated will apply a conflict of law analysis to determine the most appropriate law and the most appropriate forum, for example, whether it should be dealt by a court or a tribunal, and where the dispute shall be heard. So the court in the first instance will make that determination of whether it has the jurisdiction to hear the dispute and what should be the governing law of the transaction or of the contract. Thank you.
Wow, thanks, Mikhail. What a great presentation. I am going to have to wrap it up there. I do... Oh, sorry. One more question has just popped up. Okay. Yes, okay, yes. Mikhail has indicated that this is a good question and he should answer it. So I'll just read it out. What else is different in Incoterms 2010?
The main difference between the Incoterms 2000 and 2010 is that in the 2010 version there are fewer Incoterms now, fewer terms, 11 as opposed to 13. Also the benefit of using Incoterms 2010 is that they take into account the latest commercial trade practices. Largely there are not many changes, not many significant changes, but the wording of Incoterms 2010 has been changed quite a bit to take into account issues such as, for example, insurance. The wording clarifies the obligations of buyer and seller relating to insurance. Incoterms 2010 also now give electronic means of communication the same effect as paper communication. So electronic communication and documentation is recognized in those rules, or in 2010 Incoterms. The domestic and international transactions aspect are included in Incoterms 2010. So Incoterms 2010 clearly state in a number of places that the obligations to comply with export and import formalities only exist where they are applicable. So Incoterms 2010 can also be used for domestic contracts, not only international contracts. Incoterms 2010 also deal with issues of string sales. For example, when goods are sold during transport to another person, so the rules include the obligation to procure the goods shipped as an alternative to the obligation to ship the goods. It also addresses some aspects relating to the terminal handling charges for cargo, usually in the place of in the port of destination. So it addresses that issue as well. And another notable change is the point at which risks is transferred from the buyer and seller under some of the terms. For example, in Incoterms 2010, under FOB, the risks transfers when the goods pass the ship's rail. In comparison, in Incoterms 2010 FOB, the risk transfers when the goods are on board the vessel, so passing the ship's rail compared to goods already being on board the vessel. So these are just some of the issues, but generally there are no huge differences between Incoterms 2010 and 2000. Thank you, everyone. I will leave it to Lily now to wrap it up, and thank you for joining.
Wow, okay, that's great. Thank you very much, Mikhail. Look, we've just been overwhelmed with questions tonight, and I apologise that we just can't get to all of them, otherwise we'll be here all night, or all day in the case of some of you. Oh, and the lights have just turned off in the office here, so we've definitely gone way over time. But I'd just like to thank Mikhail for that very informative presentation. I certainly learnt a lot about international trade transactions. And thanks to everyone who joined our webinar. I hope you found it as useful as I did. Please take the time to complete the online survey that I'll be sending you tomorrow. We do very strongly value your opinion. As Mikhail said, these courses are available not only as part of our postgraduate programs, but also as vocational courses for government agencies and private industry. If your organisation is interested in a tailored course, then please send me an email with your inquiry so that we can start discussions. Here at CCES, we are always willing to discuss opportunities to tailor programs to meet the specific operational requirements of your organisation. Thanks again for attending our webinar today. I hope you can all join us again for our next free webinar within our International Trade and Border Management webinar series. The next one is Topic 4, International Supply Chain Security. That one will also be presented by Senior Lecturer Mikhail Kashubsky, who presented tonight's topic, and that'll be on Wednesday the 19th of September at 6 p.m. Australian Eastern Standard Time. So thanks again, and I'll be shutting down the webinar now.